When defending a criminal case, there are three main strategies. Which one is Donald Trump's legal team pursuing? Let's talk about it. So when you're defending a criminal case, there's three main strategies that you could pursue. The first is to say that your client is not guilty because he is factually innocent. The second is to say that he's not guilty because he is legally innocent. And the third is simply to pursue reasonable doubt. That is to say, you're telling the jury that the prosecution has not proven its case beyond a reasonable doubt. Now, let's take each of those in turn so that we can understand what is going on in the Trump trial. Now, first, as to the factual innocence theory, let's take the idea of a bank robbery. Okay? A factual innocence theory would be to say, look, someone robbed the bank. It just wasn't my guy. All right? This is a case of mistaken identity. You got the wrong guy. So you will attempt to prove in that case that your client was somewhere else, that witnesses misidentified your client, those kinds of things. There was a crime. My guy didn't commit it. The second is legal innocence. Now, for example, a case of legal innocence would be to say, I have an affirmative defense to this crime. Yes, I assaulted the guy. I punched him in the face, but it was self-defense. So legally, I am not guilty of assault. I acted within my right to defend myself. That would be a case of legal innocence. And the third would be, again, reasonable doubt. That's where you're not affirmatively trying to show anything. You're not trying to show that they got the wrong guy, that there is a factual mistake here. You're not trying to show that they're wrong on the law. I actually have a legal defense to this. What you're trying to do in that scenario is simply to poke enough holes in the state's case to argue to the jury that they did not meet their burden of proving my client guilty beyond a reasonable doubt. Now, oftentimes you'll see elements of all three of those strategies in a single trial. The defense doesn't have to pick any one of those and just stick with it. They can use all three. Usually, however, one sort of takes the lead because it's helpful for a jury for you to present a theory of the case. And if you're just bebopping all over the place, oh, he's factually innocent. Oh, but no. Maybe he's not factually innocent. He did it, but he has a legal defense. Now, those two things really don't work, okay? You need to present a theory of the case. You don't want to say, no, my guy wasn't anywhere near there. You got the wrong guy. Oh, but if you do have the right guy and it was my guy, here's why he's legally innocent. Those two things really don't go together. The reasonable doubt strategy, that's a part of every criminal defense. But sometimes it's the only strategy. Sometimes you don't have anything else but to point out weaknesses in the state's case to try to win that way. Now, with respect to Donald Trump, this is a reasonable doubt case. They have tried to argue that Donald Trump is factually innocent. You know, it wasn't him. He never had sex with Stormy Daniels. He didn't know anything about these hush money payments. But really, they're not playing that too hard because nobody buys it. And that's not going to win the day. They've tried a little bit of the legal innocence theory, you know, saying, oh, that none of this was illegal anyway. This is just, normal politics. But they haven't, again, just like the factual, they haven't leaned too heavy on this because nobody's going to buy that either. What they're really going to go hard on is the reasonable doubt strategy. They are going to basically say, their whole case is really wrapped up in Michael Cohen. They're going to tell this jury, you cannot believe anything that Michael Cohen says. And based on the fact that Michael Cohen is a convicted perjurer, you cannot find my client, Donald Trump, guilty beyond a reasonable doubt based on the testimony of a convicted perjurer. You have to have reasonable doubt based on that alone because the state doesn't have anything else except the word of a convicted perjurer. The problem for the defense here is that that's not all the state has. The state has a lot of corroborating evidence to corroborate everything that Michael Cohen is saying. That said, however, Michael Cohen's credibility could be a very big problem and could, in fact, translate into reasonable doubt in the minds of the jury. We don't know, and we have not yet seen all of Michael Cohen's testimony. As I am talking to you right now, Michael Cohen is on day 2 of his testimony. He is still on direct examination, meaning he is being questioned by prosecutors. So we have not seen the defense have an opportunity to cross-examine him. And really, the defense's cross of Michael Cohen could prove to be the pivotal part of this trial. It doesn't necessarily have to be, but it very well could be. And as you watch that cross-examination, keep in mind what I've just told you. This is largely a reasonable doubt case. And for the defense, they've thrown all their cards on Michael Cohen. They're going to try to get the jury to believe that the only evidence in this case is the testimony of Michael Cohen. And again, as I say, the problem there is that's for the defense is that's not true. There's a lot of other corroborating evidence. And what they're also going to do is try to, and this is what you do especially when you have a reasonable doubt strategy that you're pursuing, is just try to confuse the issue with as much superfluous crap as you can. Just for an example, yesterday it was brought out on direct testimony, on direct examination, that Michael Cohen tape recorded his client, Donald Trump. That's highly unusual. In some states it's illegal, but nevertheless, Michael Cohen did it. That might be one of those things that the defense spends a lot of time on, just trying to muddy the waters, confuse the issue. Whatever they can do to take the focus off of what is really important in this case, what the prosecution actually has to prove, and then instead muddy the waters with a bunch of other crap that really doesn't have anything to do with the state's case, then they're going to try to do that. And that's not a knock on the defense if that's what they do. That's what defense lawyers do. They're trying to create that reasonable doubt in the minds of the jury to get their client acquitted. It's their job. And doing stuff like that is, that's just what they do. It's what they're supposed to do. So anyways, keep those things in mind. I hope this was a little bit helpful. If you like this video, please give it a thumbs up. Recommend this channel to family and friends. And until next time, be well, and I'll talk to you again soon.